So our next speaker this evening is Professor Jason Mazzone, where he's a professor at Brooklyn Law School, and he specializes in constitutional law and theory and in IP law.
Thank you.
Thanks.
So this end of the table decided to stand. There are two parts to this paper. One is descriptive, and the other is a proposal. So let me take those in turn. A couple of years ago, Time magazine had a cover story, "Does the Supreme Court still matter?" ? And I saw this on a newsstand when I was running through an airport to catch a connecting flight. So I never found out what Time's answer to that question was. But my answer in this paper is that yes, the Supreme Court matters, but it matters much less than we think. My goal here is to shift our focus away from the Supreme Court as the place where issues of federal constitutional law are decided. My claim is that authority to determine the meaning of the Constitution is shared. It's always been shared. And my particular focus here is on the state courts, but I could tell similar stories about sharing with respect to the lower federal courts or with respect to the other branches of the federal government. State courts, I suggest in the paper, have always enjoyed a good deal of authority to interpret independently the federal Constitution. Now, historically, this was true as a statutory matter. So under Section 25 of the 1789 Judiciary Act, state court decisions in favor of federal constitutional claims asserted against state government were not reviewable in the U.S. Supreme Court. The court could only review state court decisions that rejected federal constitutional claims. And it's only in 1914 that the U.S. Supreme Court receives statutory authority to review state court decisions upholding federal claims against state government. So no state before 1914 was able to seek review in the U.S. Supreme Court of an unfavorable state court decision under the federal Constitution. State courts were able to get it wrong so long as they ruled against the state. Today, while as a formal matter, as a statutory matter, the court has authority to review any state court decision on federal constitutional grounds. In practice, the state courts continue to enjoy a good deal of independent authority. And this is for a variety of reasons that I set out in the paper. One reason is practical. The Supreme Court doesn't review many cases. So we know that the U.S. Supreme Court hears only a tiny portion of the cases that the state courts decide, I think 17 last term, even cases involving federal constitutional questions, and various people have offered views about whether the U.S. Supreme Court is able to effectively keep in check the state courts by the mere threat of review. My point of the paper is a bit different. My point is that there are lots of cases that never even make it onto the Supreme Court's radar. So let's take a criminal procedure. State courts decide most criminal cases. There's something like 20 million criminal cases filed in state court every year. Every criminal case involves issues of federal constitutional law. With rare exception, the cases that the U.S. Supreme Court reviews are cases in which the defendant has gone to trial and been convicted. Now, there's a tiny percentage of total criminal cases, and those cases are probably not representative of the entire pool. Some people are acquitted, and the government doesn't usually get to appeal the acquittal on the ground that the trial court wrongly excluded evidence or made some other constitutional error. Most defendants who are convicted because they plead guilty, often pursuant to a guilty plea. Those defendants do not typically appeal. I mean, all of those cases, the state judges have been making rulings on federal constitutional questions, Fourth Amendment, Fifth Amendment, Sixth Amendment issues, none of which are ever going to be subject to review by the Supreme Court. You could back up further and talk about cases that are dismissed or where the prosecutor drops the charges following rulings on constitutional issues. Back up further still and talk about cases where judges have ruled prior to the initiation of any criminal case on search warrants and so on. The Supreme Court, with very rare exception, there are some exceptions, but they're rare, doesn't review these rulings. So the basic point is that the set of cases that the Supreme Court could review is a small portion of the criminal cases that are out there. There are also various doctrinal rules that have the effect of giving authority to state courts. So one example comes from the takings context. As a result of ripeness and preclusion doctrines, virtually all takings claims are resolved by state courts. So Williamson County is a 1985 Supreme Court decision that holds that before a plaintiff with a takings claim can come into federal court, the plaintiff has to exhaust state proceedings, including state court proceedings. San Remo Hotel, a 2005 case, holds that after the plaintiff goes through state court, the full faith and credit statute applies and precludes the plaintiff who loses from then trying again in federal court. So state courts effectively decide takings claims. Now, it's possible, of course, at the end of the road, the U.S. Supreme Court will review the state Supreme Court's ruling on the takings issue. But there's a good case that the case also rests on a state law ground, and the Supreme Court has said on various occasions in the takings context that state courts are better positioned to resolve property disputes because of the underlying state law issues. You can tell a similar story about habeas, the various hurdles that the court and Congress have created for state inmates in the habeas context decrease the likelihood of any kind of federal review, even if the state court was wrong on an issue of federal constitutional law. Nancy King from Vanderbilt has done some recent work showing that, empirical work showing that unless you're serving a very long sentence or a death sentence, habeas review is simply unavailable because the machinery is too slow and cumbersome. You'll be released before your case is reviewed. And of those habeas petitions that are adjudicated, only a tiny number succeed. Habeas is not a check on the state courts. Across various other domains of constitutional law, other rules and features of litigation give state courts authority to resolve definitively federal constitutional questions. So let me mention three more things. One is that lots of federal constitutional issues depend upon issues of state law, whether there's a contract for purposes of the contract clause, whether there's property for purposes of the due process clause. State courts can drive the outcome of the federal constitutional claim by their analysis of the underlying state law issue. Second, resolution of federal constitutional claims is highly context-specific and turns on factual questions reviewed, if at all, on a deferential standard. And this is obviously true in the criminal context. What did the suspect say? What did the police know? And so on. It's also true in other contexts. What is the purpose of the state law under the Equal Protection Clause or under the Dormant Commerce Clause? State procedural rules prevent review of erroneous constitutional decisions by state courts. So under Caldwell versus Mississippi and Coleman versus Thompson, a ruling on a state law and procedural ground can be an independent and adequate state law ground for sustaining a state court decision. So the bottom line is that there's lots of adjudication of federal constitutional issues in the state courts that isn't subject to review or doesn't get reviewed by the U.S. Supreme Court. The second half of the paper then involves a proposal. If state courts are deciding without being reviewed issues of federal constitutional law, then I say let's make it clear as a formal matter that they have authority to do this. Allow them to rule as a formal matter on federal constitutional questions without being subject to review by the U.S. Supreme Court. And from that general idea, I settle on a proposal that's a bit more specific. I would let state courts, in cases involving federal constitutional claims against state government, to expand upon, but not to narrow, federal constitutional rights as construed by the Supreme Court. So this would be a resurrection of Section 25 of the 1789 Judiciary Act. The Supreme Court will not review any state court decisions upholding federal constitutional claims against state government. And I would start by letting the state courts do this in two areas, criminal procedure and takings, for reasons that I set out in the paper. These areas present, it seems to me, the cleanest opportunities to do this initially, while leaving the door open to some other possibilities. The Second Amendment might be an area that's ripe for this. So let me end then in the last 2 minutes just by flagging the arguments I have in the paper for why restoring the 1789 Judiciary Act limit on Supreme Court review is attractive. Well, one is it's more consistent with the authority that state courts already have today in practice, more consistent than is our current notion that the Supreme Court is the ultimate authority on the Constitution. It would allow state courts to tailor rights to local circumstances. The Supreme Court is not really able to do that. It has to set rules for the entire nation, and in doing so can't be concerned with producing optimal rulings for particular localities. It would produce some of the federalism benefits of local experimentation, and it would make state courts, I think, a bit more proactive in constitutional decision making. I think this would be good for the development of state as well as federal constitutional law. And then finally, the approach would take some focus away from the U.S. Supreme Court, and I think that this would overall be a healthy development. So rather than obsessing over what the U.S. Supreme Court is doing, we would, as we should, look more closely at how the state courts are resolving federal constitutional issues. In the casebook that I use to teach constitutional law, there isn't a single state court case on the meaning of the federal Constitution. State courts should be a part of our focus. And I came in under the radar. Thank you.
That's fast.
That was good.
See, a little time pressure is good. People start speaking a little bit more quickly. I think it's lovely. We'll have plenty of time for comments at this rate.